added institution to social security and Al-Rajaan and others part-heard.
Good morning.
My Lord, my ladies, good morning. Aeroflot. You have that in Volume 1, Tab 14 of the Authorities Bundles, and it was addressed for your note by the judge at paragraphs 437 to 442 of his judgment. The facts are important, and the relevant facts for present purposes of Aeroflot are these. Claims were brought by Aeroflot in England against certain anchor defendants, together with 4 overseas companies, abbreviated in the leading judgment of Lord Justice Aikins to Holdings, Services, Cyprus and Finance. Holdings was domiciled in Luxembourg, and that is a critical fact. Services was domiciled in Switzerland, Cyprus was domiciled in Cyprus, and Finance was domiciled in the BVI. Aeroflot sought to join Holdings, Services and Cyprus to the English proceedings under Article 6.1 and to serve finance out of the jurisdiction in the BVI under the CPR. Services challenged jurisdiction on the basis of a Swiss jurisdiction clause and, alternatively, a Swiss arbitration agreement. Cyprus challenged jurisdiction on the basis of an arbitration agreement. Holdings contended that Article 6 was not satisfied, and Finance challenged jurisdiction on various grounds. Now, it's the position of Holdings which is important in our case. And the argument which Holdings made, and it was made by my learned friend Mr. Tregear and opposed by my learned friend Mr. Marshall, so we've got, as it were, the full suite in front of us. The argument was summarised at paragraph 13 of the judgment at page 275. And I'd invite you to read that paragraph, please.
Sorry, paragraph?
Paragraph 13, page 275 of the bundle.
Yes.
Now, Lord Justice Aikins considered the exclusive jurisdiction agreement and arbitration agreement challenges raised by services and the arbitration challenge raised by Cyprus first. He took that step first before coming on to consider the Article 6 challenge raised by Holdings. And of course, just pausing there to note, that is the course that the judge in our case also adopted. He concluded, Lord Justice Aikins concluded that Services was entitled to rely on its Swiss exclusive jurisdiction clause and therefore could not be sued in England because of Article 23 of the Convention. And he concluded that Cyprus was entitled to rely on its arbitration agreement and therefore the claims against it had to be stayed under Section 9 of the Arbitration Act 1996. He then considered the challenge mounted by Holdings under Article 6 in light of those findings, again, the same course that the judge in our case took, and he did that at page 305, at paragraphs 111 to 113, that's 305 of the bundle, which you have read during the course of my learned friend Mr. Beard's submissions. The critical passage for present purposes is at the start of paragraph 113, and I want just to read that to you again. Aikins LJ at this stage has concluded that Holdings, there's a risk that if the case against Holdings was tried in Luxembourg, being its jurisdiction of domicile and therefore where it had to be tried against Holdings absent Article 6, if that case was tried in Luxembourg and the anchor claims were tried in England, then there was a risk of irreconcilable judgment. And then he addresses Mr. Tregear's argument about the existence of the claims elsewhere at paragraph 113. And he says this: Mr. Tregear argued that there was a much closer connection between the claim against holdings and those against services and finance, and that the risk of irreconcilable judgments in different jurisdictions was greater in respect of those claims. Now, just pausing for a moment, although it doesn't actually matter for present purposes, it's pretty clear that the reference there to finance was a mistake, and it should have been a reference to Cyprus. That's a point which the judge in our case, you may recall, picked up in his judgment, and one sees that from the last sentence of paragraph 111 of Lord Justice Aikens' judgment. As I said, it doesn't matter. So he says that. And then he says this: that may be so, but it is irrelevant. If Aeroflot pursues services, it must do so on my ruling in the Lausanne court, and if it pursues Cyprus, it must do so in arbitration. So necessarily there are going to be different tribunals that deal with each of those claims. Now, why, and this is the critical question, is Lord Justice Aikens saying that the claims against services and Cyprus are irrelevant? Piffs seeks to suggest that he was saying that anything other than a consideration of the claims against the anchor defendant and the target defendant was irrelevant as a matter of principle under Article 6. But that's not what the paragraph says, and it's not, we suggest, what it means. The principal reason why it was irrelevant that those claims would be on foot in any event, i.e. why it was irrelevant that there was, as Mr. Tregear had argued, a closer connection between the claim against holdings and the claim against services and Cyprus. The reason why it was irrelevant was because it would not in any event be possible to sue holdings in the arbitration against Cyprus or in the claim against services in Switzerland. That was because holdings was a Luxembourg domiciled entity which would have to be sued in Luxembourg, at least absent an undertaking from holdings to submit to the Swiss jurisdiction. No such undertaking was proffered by holdings. None is recorded in the judgment as having been offered, and my learned friend Mr. Tregear, who we have here, has confirmed that he was not instructed to offer one in that case. So the upshot is that the risk of inconsistency between any judgment against holdings and any judgment against services or Cyprus would not be reduced in any way by the English court declining jurisdiction over the claim against holdings.
Because it was inevitable.
Exactly. It was inevitable, and it couldn't be made better by declining jurisdiction against holdings. In fact, and this is a point which the judge in our case picked up, it would be made worse. Because rather than having 3 sets of proceedings in convention states or regulation states throwing up risk of irreconcilable judgments, the claim in Switzerland, the arbitration, actually the arbitration isn't a proceeding in a convention state in that sense, but let's just stick with the claim against in Switzerland and the claim in England against the anchor defendants. Rather than those 2 plus the arbitration, 3, you'd have 4, because you'd have a claim against holdings in Luxembourg.
Is your point summarised by saying that when Lord Justice Aikens said that it was irrelevant, that he was meaning that it was relevant in the circumstances of that case, rather
Yes.
than pronouncing a point of principle?
Yes, that is precisely my point. And that point is, we would submit, underscored by the fact that he goes on to explain the circumstances of that case in the immediately following part of his judgment.
And in a separate point, in doing so, considers potential, not only extant proceedings.
Yes, indeed. I mean, absolutely on all fours with our case, because the proceedings are only going to start, I should say, in Lausanne, in Switzerland, as a result of his conclusion that the claim against services is governed by an exclusive jurisdiction clause and therefore can't be proceeded with in England. So it's got to go off to Switzerland. So the judge, in our case, was entirely right, and for the reasons that he gave. And it is perfectly clear, we submit, why Lord Justice Aikens concluded that the existence of the claim against services and the arbitration against Cyprus was irrelevant. because holdings couldn't be tried in either of those places, alongside either of those claims. And it would have made, as I've explained, the position worse. That is, of course, critically different from our case, and it's also worth noting it's critically different from the position that pertained in Alpha Laval, because in Alpha Laval, SSIP, the target defendant, was domiciled in Poland, where Mr. Jasikowski was domiciled, and where, following the decision of Lord Justice Longmore, Mr. Jasikowski had to be sued. So Aeroflot is distinguishable from our case, and it is different from Alpha Laval, to the extent that it's not. Alpha Laval wasn't cited in Aeroflot, it's not in the judgment, it's not referred to in the report, and my learned friends don't recall it having been cited by them in the course of argument. And so, to the extent that one needs to say this, it was pure incurium, but one doesn't need to say it in truth, because it's perfectly reconcilable with what Lord Justice Longmore says. Sorry, Aeroflot is perfectly reconcilable with Alpha Laval, as it is with the judgment in our case. So Aeroflot does not assist PIFs, and nor do any of the other authorities.
Can we just look and see what the judge did on this?
My lady, yes.
He makes large chunks of Aeroflot are cited, and then 439, page 466.
Yes. My lady, yes.
And your point is, well, he makes your argument at 440.
He does. There's
in any event going to be fragmentation.
Yes, he makes both the points that I've made at 439 and 440. And the critical bit is the second part of 440. Since the claims against holdings could not be pursued in the same forum of those against Cyprus and Cyprus, there was in any event going to be a fragmentation of proceedings as regards the claims against the various corporate defendants. I can claim no special pride of authorship of my submissions. They all come from the judge's judgment. My lord, my ladies, that's what we say about Aeroflot, and none of the authorities that my learned friend referred to assist. I've covered a number of them. Time hasn't permitted to cover all of them. That submission includes the decision of the Court of Justice in Reich-Montage. My friend, I think, sought to suggest that it might be taken to establish a principle that one must look only at the state of play at the time the claims are issued. Your lordship and your ladyships will see when you go back to the judgment of paragraphs, in particular 26 to 31, that is not the principle that case establishes. It turns on the well-established principle of European law that matters of national law, including the admissibility of claims under national law against an anchor defendant, must be left out of account when considering the operation of the autonomous rules of the Convention. So, on the issue of principle concerning Article 6, the judge's approach was correct as a matter of language, it was correct by giving effect to the purpose of the article, and it was in line with the authorities as to how the article is to be applied, including the decision of this court in Alpha Laval. That leaves the challenge made to the judge's application of the test in this case. That, of course, is dependent, it changes with the individual respondents. My client, Mr. Berterat, is in the same position as the Pictet defendants. And I need to say very little about that, not least because it was not addressed orally by my learned friend. We've addressed the point in detail in our skeleton at paragraphs 33 to 41, and the judge considered the position in considerable detail, so far as concerns the Pictet defendants and Monsieur Berterat at paragraphs 447 to 460 of his judgment. In doing that, he conducted his own evaluation of the position by reference to the relevant facts, something, of course, with which this court will be very slow to interfere, absent an identifiable flaw in his approach, of which there is none. And indeed, I've made so bold during the opening part of my submissions as to submit that if one gets the test right, as we say the learned judge did, then the result, when it's applied, is blindingly obvious. he concluded that the factual foundations of the C claims against the Pictet defendants and Monsieur Berterat was the same as that of the A and B claims, namely that they knowingly connived in and facilitated the alleged wrongdoing of Mr. Al-Rajaan from the outset, and he therefore rightly concluded that if the C claims were pursued in England and the A and B claims were pursued against the very same defendants in Switzerland, then there was a very real risk of irreconcilable judgments on exactly the same issues against exactly the same defendants, and that this would create a greater and less acceptable risk of irreconcilable judgments than that which would be created if the C claims were pursued in Switzerland. That is a conclusion we submit which was unimpeachable. My lord, my ladies, one final short point. My learned friend sought to make something of the fact, supported by the annex to his skeleton argument, that the value of the C claims is substantially greater than the value of the A and the B claims. That is a point that we submit which is completely irrelevant to any evaluation of the expediency of accepting jurisdiction over the C claims so as to avoid the risk of irreconcilable judgments. The fact that the value of the C claims is much greater than the value of the A and B claims has no bearing on the risk of irreconcilable judgments at all, and therefore it is simply to be left out of account. My lord, my ladies, that's what I wanted to submit. Unless I can assist you any further, those are my submissions.
Okay, thank you very much indeed, Mr. Acton. Yes, Mr. Marsh.
My lord, my ladies. I appear for Mr. Amouzagar, who is the fifth defendant. He is domiciled in Switzerland and would, in the normal course, be expected to defend proceedings there rather than in England as a result of Article 2 of the Convention, the Lugano Convention. The appellants seek to join him under Article 6. However, if the Pictet defendants must be subject to proceedings in Switzerland, we respectfully submit that this makes no sense and would not be expedient, using the language of Article 6, given that Mr. Amouzagar is central to the claims against the Pictet defendants. His actions and his knowledge are sought to be attributed to Banque Pictet, and it is alleged that the bank is vicariously liable for what he is alleged to have done. And it would be highly undesirable, in the sense of the word as used in the judgment of Lord Justice Mummery in the research and motion case to which you've already been taken, and in the sense of creating an obvious risk of inconsistent judgments were the bank, Pictet, to be pursued in Switzerland, and Mr. Amouzagar to be pursued here in England. And all of these points apply, whether one considers the pleading as it stood before the learned judge in the court below, or the more recently revised version of the pleading, which the appellants, I believe, wish to rely upon for the purposes of this appeal. I gratefully adopt what Mr. Adkins has said regarding the applicable legal proceeding principles, and I don't propose to repeat any of those. I would just simply emphasize 2 points. The first is the evaluative nature of the exercise, which is something we get from the research in motion decision, in particular the judgment of Lord Justice Mummery at paragraph 37. And the second is the observations of Lord Justice Longmore in the Alpha Laval case regarding the fact that one takes account of prospective proceedings abroad. And in that regard, I just wanted to draw attention to the fact that the situation in this case is somewhat stronger than in Alpha Laval, as a result of documents that have been served by the appellant. And you will find one of these in Core Bundle Volume 1, tab 16, page 256. If I could ask you to look at that. This is a document called a Commandement de payer, served on Mr. Amouzegar in January of this year, and it's
Just hold on a second. Hold on a second.
I'm sorry.
This is the stuff clipped to the back of your skirt and
It is indeed. And it's a demand for the payment of an amount in Swiss francs of just over 272 million Swiss francs. The description is in French, but I think it's reasonably evident that it's concerned with the allegations which feature in our own case, covering the period between 1998 and 2015. The figure of 272 million Swiss francs we understand to be the same amount, albeit converted into dollars, as features in the pleading at paragraph 205, and for your reference, that's in Call Volume 3.
Before we leave this, is this a claim?
What we understand it to be...
The document we're looking at here?
Yes, what we understand it to be is a document that one serves in order to preserve the limitation period or prescription period under Swiss law.
Yeah, I was going to say it must be part of the legal process in Switzerland.
Quite.
It's a preventative. It must engage jurisdiction or preserve the situation somehow.
Exactly.
So it's an order to pay.
Exactly. And it's designed to maintain the limitation period so that the proceeding can be brought in due course.
Yes.
And sorry, my lord, I was just giving you the reference, which is Call Volume 3, tab 31, page 659. It's paragraph 205.
And so PIFS has got Swiss lawyers.
Oh, yes, indeed, they do, yes. In fact, there were originally Swiss criminal proceedings in which PIFs were a civil party represented by Swiss counsel. But their participation in those proceedings, they terminated in order to then bring proceedings in England. But these Commandant de payer documents have been served more recently, presumably with the intention of preserving the position to enable them to proceed further in Switzerland if they so wish.
Sorry, and the point is?
And our point is that that reinforces the position that we have the potential, the real potential for future proceedings in Switzerland, which will give rise to a serious risk of inconsistent judgment. Now, in terms of how the risk arises in connection with Mr. Amouzegar in particular, with your permission, I was going to show you in a brief way the way in which the matter is pleaded. For that, we need to go to the pleading in Call Bundle Volume 3, tab 31, at page 646.
Yes, paragraph.
And if we could look first of all at paragraph 168, there one will find pleaded the Pictet scheme, section G of the pleading, which initially pleads how Mr. Al-Rajaan came to have dealings with Pictet, which was said to be through his contacts and a prior association with Mr. Amouzegar and or Mr. Bertherat. And after those initial paragraphs, one then has a section which really sets out the actions of Mr. Amouzegar, which are said then to also engage Pictet. And there is a sequence of agreements that are pleaded, beginning at paragraph 172, at the bottom of page 646. And it's alleged that on dates unknown but prior to August 1998, there were discussions that Mr. Al-Rajaan had with Pictet, and then you will see the pleading is through Mr. Bertrand and Mr. Amuzagar. Now that's a style and a theme that carries all the way through, that there's alleged to be, if you like, joint action between Mr. Bertrand and Mr. Amuzagar, which then engages the bank. And the agreement that's pleaded here is the one that's said to be in respect of securing secret commissions and also putting in place an offshore corporate structure, adopting a mechanism whereby payments would go through a Mr. Nasrallah.
That's A and B. A and B.
Exactly. Yeah. And that's then carried through with various extensions and variations in subsequent passages. For example, in paragraph 175, you will then see a further or subsequent agreement alleged to have been made. Again, it's with Mr. Bertrand and Mr. Amuzagar on behalf of Pictet, extending the categories of services on which secret commissions are said to have been payable. Here it's said to be global custody, brokerage, and net security lending. At 176, there is then a further agreement. I think they've adopted the terminology, the Pictet-Nasrallah agreement. This one's said to be in March 1999. Again, Pictet is said to have acted through Mr. Bertrand and Mr. Amuzagar in respect of a business finder agreement. And then if we go on to page 649, at paragraph 183, there's then alleged to have been a variation of that agreement, the Pictet-Nasrallah agreement, in March 2001. This is to provide for commissions at a particular rate, and the way in which it was alleged to have been entered into, again in paragraph 184, is, so far as Pictet is concerned, it's through Mr. Bertrand acting in conjunction with Mr. Amuzagar. And in this context, it relates to the management of a particular fund called the Maya Fund, or so it is said. And we have a similar and final reference on page 650, at page paragraph 187, further agreement in February 2006, whereby Pictet, acting again through Mr. Bertrand and Mr. Amuzagar, confirm a higher rate of commission payable of 40% in respect of performance fees, which is alleged to have been an increase designed to enable secret commissions to be taken. So having pleaded all of these various agreements and actions, which are joint actions of Mr. Bertrand and Mr. Amuzagar on behalf of Pictet, so it is said, we then get the allegations of knowledge, and those begin on page 651 at paragraph 192. And again, one sees the allegation of knowledge where it is sought to be attributed to the bank is that of Mr. Bertrand and Mr. Amuzagar. 192, insofar as the Pictet-Nasrallah agreement, each of Mr. Al-Rajaan, Mr. Nasrallah, Mr. Bertrand, and Mr. Amuzagar at all material times knew that, and then various things are then set out. And one moves on to page 653, paragraph 199. Reliance is placed at 199 on the fact, so the claimants allege, that Mr. Bertrand and Mr. Amuzagar were responsible for and had continuous oversight of Pictet's relationship with Mr. Al-Rajaan and various other parties and the relevant accounts, which were held with the various Pictet entities. And it was said that this continued even after Mr. Amuzagar had left Bank Pictet as an employee in 2003. And at paragraph 200, after pleading how various accounts were managed centrally. In the last sentence of paragraph 200, it's then again alleged that Mr. Bertrat and Mr. Musagar had knowledge and overall supervision of all of the Al-Rajaan and Najralah's accounts, including on behalf of Pictet Bahamas, Pictet Asia, and Pictet Europe. There's then a further set of pleas in connection with concealment and general assistance in relation to unlawful schemes. For example, on page 655, paragraph 204, there's an allegation of concealment, and again, this one is alleged to have been carried out by Mr. Bertrat and Mr. Musagar together, acting on behalf of Pictet. Conceal the payments of commissions under the Pictet scheme, and then various mechanisms for that are then alleged. And at page 659, paragraph 205, there's then assistance in relation to other unlawful schemes, and this is where we had that figure of $294.2 million, which we believe to be equivalent to the Swiss franc figure that appeared on that commandant de paix that we looked at earlier. This is alleged to have involved not only the amount paid to Pictet directly, but also other amounts paid in relation to other schemes, as one sees from A and B under the first A and B under paragraph 205. And what then one has is an allegation of knowledge in relation to all of that, which begins on page 660. And if I could take it up particularly at paragraph 209, where you will see the allegation that Mr. Bertrat, all times up to May 2012, and Mr. Musagar, prior to 2003, were managing the relationship between Mr. Al-Rajaan and his nominees and their companies on behalf of the other Pictet defendant entities, such that their knowledge is to be imputed to each of those entities as principal, as well as to Pictet. So there's the plea of attribution, and it's a joint one in respect to Mr. Bertrat and Mr. Musagar. You'll also see at page 661, paragraph 210, the additional plea that there is vicarious liability on the part of the Pictet companies and bank for the conduct of Mr. Bertrat and Mr. Musagar. And it then concludes at paragraph 211, accordingly, each of the Pictet entities, through at least Mr. Bertrat and Mr. Musagar, and those working under their supervision, knew that the sums transferred into the above accounts pursuant to the Pictet scheme were secret commissions by reason of the facts and matters pleaded in connection with that scheme. And there are also further reliance on earlier passages in paragraph 212 and 213. Accordingly, the Pictet entities, and each of them, through at least Mr. Bertrat and Mr. Musagar, and those working under their supervision, knew. And then there are various allegations about the secret commissions and facilitation of payment of secret commissions. So we respectfully submit it's quite clear, therefore, that if one had a separate set of proceedings in Switzerland against the Pictet entities, from proceedings against Mr. Musagar in this jurisdiction, one would have the highest risk possible, really, of a conflict in decision, given that Mr. Musagar's actions and knowledge are central to the claim against Pictet.
So your case is it would be bizarre if he was dealt with differently to them.
Quite.
Is anybody saying he should be?
That's the case of the appellant.
Yes, I mean, I understand. But in reality, is anybody saying there should be? I mean, I understand that the point is made, has to be made with relation to each specific defendant. But are you able to identify any reason for picking off Mr. Al-Rajaan and dealing with him differently that is being launched against you?
Nothing more than the fact that he hasn't got an exclusive jurisdiction clause in his favour because he wasn't a part of the bank. That's the one distinction.
That's the one distinction. No other distinction is being pressed.
Not as far as I'm aware.
Right. No EJC.
That's it. And well, just to conclude on this, a careful analysis of each of those passages that I've taken you to was conducted by the learned judge in his judgment, in particular paragraphs 472 to 479. I shan't take you through them now, given the limitations of time, but you will see all being assessed there very carefully. And he particularly took on board and weighed in the analysis the contention of the appellant side. Well, there's still going to be the Type C matters. They're still going to be addressed in England, and there's a closer connection, if you like, with those matters, and greater risk of irreconcilable judgments if those matters are dealt with separately in England and Mr. Ramuzagar is pursued in Switzerland. That was the contention. The learned judge weighed that into the balance, but nevertheless concluded that there was, on balance, a higher risk of irreconcilable judgments if Mr. Ramuzagar was to be pursued in England rather than in Switzerland, if the Pictet defendants were going to be pursued in Switzerland.
Now, the judge said that the position on Article 6 in relation to Mr. Ramuzagar was more finely balanced than in relation to the other individual defendants. Would you like to address us on the reason why he found it more difficult against your client, looking in particular at paragraph 477?
Yes, I think it was
478 the judgment.
It was the concern
particularly
that
Mr. Argon, isn't it?
Mr. Al-Rajaan's position would have to be considered, and there would be a possible risk of inconsistent findings in connection with Mr. Al-Rajaan.
So his point was that all of the instances that you point to involve interaction with Mr. Al-Rajaan, who of course is going to be sued here.
Yes.
So that was his hesitation.
That was
would
his
you like us
hesitation.
to address us on that particular point, because that's the issue?
I would respectfully submit one could quite well come to conclusions as regards Mr. Al-Rajaan's position and what he knew and what he might be liable for, without there being any inconsistency or any risk of inconsistency with regard to Mr. Ramuzagar, who is actually on the other side, if you like, of the transaction. Much more difficult, though, when looking at the position, for example, of Mr. Ramuzagar and Mr. Berthra, who are both on the Pictet side of the transaction and operating together. Much higher risk, we would respect to submit, of irreconcilable judgments there, particularly so where Mr. Ramuzagar's knowledge is sought to be attributed to the bank. And the basis of his knowledge is essentially the same matters as are being relied on in relation to Mr. Bertrand as well. But it was effectively an evaluated exercise that the judge was conducting here, looking at the overall position of where the risks most substantially lay. And we would respect to submit that exercise was done carefully, and there's no reason to conclude that there's some lack of logic or some inconsistency in the way in which the learned judge approached it. And we would respect to submit the approach in those circumstances is that this court would be very slow to disturb what the learned judge has concluded. And for that, I rely upon the re-sprint room decision, which I think we've been referred to in the skeleton arguments. I can show you the passage if that would be helpful.
Sorry,
This is the case of re-sprint room. It's in the Authorities Bundle Volume 3 at tab 23.
this is
Tab 23.
2.
Sorry, 2 tab 23. And the passage is just concerning the approach at appellate level to evaluative exercises of this kind. and the passage that we respect to submit is relevant and important to bear in mind is on page 669, using the bundle numbering. That's paragraph 76.
It's very well established.
It's well established.
Different judges may disagree and still be right.
Quite.
And once the judge has made an evaluative assessment, if there's no error of law, whether we agree or not, it's neither here nor there.
Absolutely. I see the time. I may have strayed slightly beyond my allocated amount. So, unless I can assist you further, my Lord and Lady, those are our submissions in relation to this removal submission.
Yes, Mr.
My Lord, my Ladies, we're all dealing with constraints of time. I hope to finish by 12. I'm making submissions on behalf of Mirabeau and C. S.A., which is the other scheme, or alleged scheme, if I can put it that way. I appear for Mirabeau with Tony Simler, Queen's Counsel. Following my submissions, which are going to deal with material validity for the purposes of Article 23, counsel for Pierre Mirabeau and Thierry Fauché-Magnan, who were partners, will make submissions particularly relating to Article 6 and their position, and then submissions will be made on behalf of Mr. Al-Rajaan, who is also related to aspects of the setting up
So
of the issue.
the scheme of things is that an hour will be allowed for those collectively.
That's how it's
But
working.
everybody's
I'm
happy
being
with that answer.
squeezed. They may be squeezed, but I'm just putting it out there so that I will deal with the material I need to deal with as quickly as I can, but also in a way which I hope is helpful. So I'm not going too fast or making my submissions with haste but not effectiveness. In relation to the Article 23 and material validity, my Lady Justice Carr asked my then friend Mr. Beard for a route map in relation to Article 23 and material validity, because there is a skein of interrelated factors that need to be considered in a particular sequence. And my learned friend Mr. Beard helpfully produced a route map. And my Lady Justice Carr said on day 2, right at the beginning of the session, I think it's on page 1, at the end of the first page of the transcript, that logically one starts with the relationship in connection with which the exclusive jurisdiction clause, well, not logically, but one can.
The judge did.
The judge did.
I think Mr. Beard, as ever, very fairly
Yes.
accepted. Order doesn't
No.
matter. He was responding to my request for assistance.
Exactly.
The judge certainly, nobody objects to the order in which the
No.
judge, and it's reflected in the agreed list of issues.
It-
The first question is, forgive me,
Yes.
in connection with what particular relationship were the EJCs agreed? And you say that's important because that underlines the correctness, you would say, of the judge's approach to analysing the contents of the EJCs
Yes.
and their scope, because
Yes.
that informs the question.
Precisely, because until one's done that, it's very hard to answer the question to the extent, what is the extent to which the claims or the matters in dispute arise in connection with the particular legal relationship, which is the Article 23 wording, or originate from or arise from using the wording which we see in Powell-Dufferin.
Yes.
But that order is really how paragraph 31 of Powell-Dufferin is structured. It's how Mr. Justice Jacobs approached the matter in Etihad. It's how Mr. Justice Henshaw, in our submission, entirely correctly approached the matter. And I will, for the purposes of our submissions, if I may, deal with it in that order. And so what I will do is examine the relationship in connection with which the EJC was agreed. And that will involve looking a little bit at the agreements which were formed, not exhaustively, because no points are really taken on minute matters of construction, but it's our submission the court will need to have a picture of what those agreements are. And to a large extent, I can do that by reference to the judgment, because a learned judge looks at those agreements. And then having looked at the agreements, I will then look at some of the facts which show what the parties did following on the creation of this agreement. Because in our respectful submission, it's no good just looking at a contract on day 1 and saying, well, you've opened an account, so what? What one needs to look at is what did the account do? What, within the framework of the contractual relationship engaged on, in this case, the 20th of January 1997, what was done? what were the legal relationships that arose in relation to that contract? And
Is that right? I mean, that's a belt and braces, perhaps. I mean, logically, you look at the situation at the time the agreement was made,
Yes.
for the purpose of your first question.
of course,
So to what extent is it legitimate to look at what the parties did to answer that question under Article 23?
it's really because my learned friend Mr. Beard says, well, that's all you need to look at. So you can ignore the terms of the agreement that don't relate to the account opening. And what Mr. Beard says in criticism of our position is we're reversing the terms of the agreement which relate to matters like commission payments and all the other matters which the learned judge took into account. And thus we're at risk of taking a far too broad account. He says all those matters which are dealt with in the contract, apart from the opening of the account itself, are irrelevant. We're just looking at the opening of the account and not what actually happened. But what happened is what gives rise to the legal relationship in connection with which the exclusive jurisdiction clause
they were ongoing and they changed.
Yes, exactly.
So to that extent, you're not looking at what the parties did so much as the fact that the conditions were repeated and amended.
Yes.
And we're looking at all of the EJCs, aren't we? We're not just looking at the EJCs on day one.
No, we're looking at all the EJCs, and logically one ends up with the 2016 EJCs,
Yes.
which were agreed. But there was, from 1997, a sequence of EJCs within the framework of the GTCs, if I can call them that. But my learned friend, as I understood his submissions, was rather saying to the court, well, you don't really need to look at the rest of the contract, because what Mirabeau is doing is trying to reverse all those terms to say, look, the relationship was much bigger.
I missed that, but I mean,
Well-
maybe you're right, but I mean, certainly, surely for the purpose of proceedings commenced in 2019 or
Yes.
2020, the relevant EJCs are those in force in 2016.
Of course. And
So you have to move through them, don't you?
well,
That's
we have.
your case.
Yes, we say they were there from the inception. By the time you get to 2016, what's the relationship you got at that point? That's one way of looking at it. Or one can look at the GTCs and say, well, the relationship which is created is one where the parties have an expectation that the following things will be done in pursuit of the contract. And then you ask yourself, well, what does the EJC refer to? It refers to the relationship created by the contract. So I understand it. My learned friend is trying to say, well, it's just an account. Everything else to which this dispute relates is happening somewhere else.
And what's the significance of the word particular, a particular legal relationship?
Well, I'm not sure. It doesn't involve a narrowing.
It doesn't.
It involves the relevant, if I can put it this way.
Right.
Because
It's an identifying word.
yes,
It's
not a specific. I think the learned judge made the point that. Well, I mean, the obvious example is that Mr. Mirabeau is driving a car in London and knocks an agent of PIFs down at a zebra crossing. Well, there is a relationship between the agent of PIFs and the bank, but the relationship which is created by that accident and the liabilities that arise has nothing to do with a particular legal relationship. It doesn't mean it's a tiny legal relationship, or you just say, oh, you open an account, so what? I think one then just needs to look a little bit at what the relationship that was created, that it had a
You have
reality.
a situation where you have multiple reforming contractual documents, and over the course of that whole period, you have a sequence of conduct which is alleged to be tortious.
Yes.
Then doesn't one essentially, unless there's some reason not to do so, look at the whole picture, because you have to compare the relationship as you assess it
Yes.
with the dispute, and the dispute is not just on a particular day. The dispute is in relation to a continuing course of conduct in this case.
And the relationship is a factual question, which the learned judge addressed in that way, and he was being asked to take the view that what was termed in the court below a vanilla banking contract was a very limited exercise, and the learned friend has reiterated that to a certain extent by saying it's one contract, to which our answer is so what? Because the question is, what was the relationship created by that one contract? In the same way as...
So, I'm just saying that it doesn't seem to me to be particularly helpful either to look at what just at the beginning or just at the
No.
end, or indeed just at any other particular point of time in the middle.
Well, to a certain extent, one can see the legal relationship from the way the case is pleaded against us, because the things that we are said to have done. All I was going to say is that in terms of looking at the contract, I will look at a few documents which just show, if you like, in real time, what it is that is alleged in the particulars of claim, which show that the relationship was one which went far wider than just opening an account, or that Banque Mirabeau was no more than a passive custodian who did nothing else. And I think that the Lady Justice Carr asked my learned friend, Mr. Beard, well, what is the relationship? And my learned friend did accept that it was bank and account holder. And in a sense, we would respectfully submit that's enough for us, because we would say that these disputes relate to or arise from the relationship of banker and customer. And that's all one needs to do. And I will try not to test the patience of the court, but there are just one or two documents which, in our respectful submission, are helpful, because there is one difficulty.
And are they referred to in 227 to 232 of the judgment?
They are referred to in the judgment. Well, they're referred to when the judge is dealing with the legal relationship, yes, and we'll look at that. But the one danger I was going to try to avoid, if one argues this appeal at too high a level, there is a danger that one's arguments can become separated or divorced from reality. So and to a certain extent, the court has been confronted with arguments at a relatively high level, because we haven't actually looked at any, if I can put it this way, any of the flavour of the legal relationship, or much of the detail of the disputes and how one makes that connection.
Well, something we mentioned on day one.
Yes. Well, I'm taking my cue from that. I hope not testing the patience of the court, going to look at those matters, not in burdensome detail, but I hope in helpful detail. So what I will cover in our submissions is a quick look at the contractual documents, so we just know what we're looking at. So far as the EJCs are concerned, they're all contained in, I think, volume 3 of the core bundle, and I'll get the reference there. I think it's tab 35. But there is a... we've
in volume 4.
Volume 4, I think that's right. And it's tab 35, I hope,
Yes.
which is in Mirabeau. I'm not sure we need to look at them now, but I'm just saying for reference, all the EJCs in sequence from 1997 onwards, contained in the signature card and various other documents, are there. I think we can find. I think I can do enough just by referring.
I mean, speaking entirely for my own part, I'm interested to look at
Yes.
some of these.
Well,
So
let's look at
if they're relevant.
tab 35. What we've done there is simply pull them all out. Now, to some extent, what we've done there is then take them in isolation from the other contractual terms, which we say are relevant to the legal relationship created, and then which endured. I think the 1987 GCCs one can take away. What happened at the beginning of this claim when Mirabeau made its application contesting the jurisdiction of the English court was effectively to assemble all the contractual documents relating to Mirabeau and Peace and exhibit them all in order to make good the case that there were EJCs.
Sorry, but when did the first account get opened?
The first account, the only account, got opened on the 20th of January 1997.
Yes. Right.
And one sees, if your ladyship looks across to the next page, page 1007. The bottom of page, sorry, it's a landscape document, but second entry in 1006 is some GTCs which were in Peace's possession on their file. The judge held that those are most likely to be the 1997 version, which was handed to Peace at the time the account was opened. So that's the clause 16 contains the choice of law, choice of forum clause. At the same time as the account was opened, a signature card was signed, so effectively the signatures of the personnel of Peace who could authorise instructions to the bank. And the signature card, which is at the top of page 1007, if one has it that way around, has the entire contractual relationship between a client and Mirabeau should be governed by the bank's present and future general terms and conditions. And then there was a choice of forum clause within the signature card. There were two sides to it. There was a signature on one side and this rubric on the other. All legal aspects of the relationships between the client and bank should be governed exclusively by Swiss law. place of performance, as well as exclusive jurisdiction of lawsuits and any other kinds of legal proceedings shall be Geneva. And what then happens is that periodically further terms and conditions are sent. In 2007 and 2008, PIFs actually sign the GTCs which are sent to them, and one sees that on page 1008, second entry, and then 1009, first entry. There was an issue which doesn't matter as to whether it mattered that PIFs had the English version, not the French version. It didn't matter. And then, my lady, we go on, and the court will have seen from his lordship's judgment in the court below that he did not consider that there was a significant difference over the period from 1997 to 2016, when these accounts were finally closed and all the assets moved from Mirabeau back to PIFs. There was no significant difference in the scope or coverage of the EJCs. So I mean, that's where they are, but they've been extracted from the contracts for the purposes of setting them all out. We will, if I may, just look at a few terms in the contract, but possibly by reference to the judgment, because the learned judge does deal with that issue. But the ground I was proposing to cover was the contract, some factual evidence as to just what was happening, then the pleaded case, and then I'll address the court on why we respect to submit the learned judge was entirely correct to say that these claims, so far as A and B, arose from or had a sufficient degree of connection with a legal relationship created by the contract. If I have time, I'll deal with the points which are made against the learned judge's conclusion in detail in oral submissions. Otherwise, I'll refer the court to where they are in our skeleton arguments so that the court can see them. I will address the court very briefly on the respondent's notice, which deals with C. It's a short point, and where we say that the learned judge went wrong. Before I get to those points, which I hope we can deal with fairly quickly, we would, with the court's leave, make certain submissions about what we would say was the weakness of the appeal as it developed in the course of day one, day two, particularly day one. And just remind the court that on the afternoon of Monday, my learned friend was asked to identify by reference to the judgment on the material validity point, points with which he took issue in the judge's conclusions. And in our respectful submission, that was an important part of this hearing, because as my learned friend took the court to various paragraphs, my Lord Justice Peter Jackson asked, well, will you tell us where you take issue with these points, with these paragraphs in the judgment? And as one went through the judgment, on the judge's directions to himself on the law, so far as material validity was concerned, one saw very little explicitly was said as to why the judge had gone wrong.
Well, what was said was that it was errors of omission rather than...
Precisely. But there were important areas of what the judge said, which in our respectful submission have an impact on the submissions that PIFs made. And in particular, I'm not sure we need to go to it, but paragraph 199, where the judge expressed the view that the approach of the authorities, which he set out at the beginning of 199, I won't go to the whole of that paragraph, but just at the end, because my Lady Justice Carr specifically asked my learned friend, what about the last part of paragraph 199, where the judge said that approach, by reference to the cases, does not imply any narrowing of the nature of the connection required between the claim and the legal relationship in question. The question remains whether the claim arises in connection with a legal relationship. So that's absolutely the words of Article 23. And we would respectfully submit that originating from, arising from, linked to, materializing in, are all ways of expressing Article 23. You're not supercharging Article 23 and saying, oh, a connection has to be intense, or connection, if you like, there's a presumption of exclusion unless you can make a very good connection. They're all cases in which the judges concerned are expressing in ordinary language the nature of the connection. And in a way, they're looking for a different word for connection, because you're already talking about it in connection with what legal relationship is the EJC agreed. And then, so you then say, well, it was agreed in connection with that legal relationship, and the claims arise out of that legal relationship. So there's no magic about the words. There's no semantic arguments to be had. And I don't think we need to deal with it in detail. In my learned friend's supplemental skeleton, and in the first skeleton, a particular point was made. The judge was wrong when he talked about the claims being connected with the legal relationship, because he should have used originate from, because that's what Powell Dufferin says. I don't think we need to go to the skeleton in that respect, because orally no submissions were made on the basis that the judge made a mistake by using connection instead of originate from, and therefore the judge went far too broad. And the thrust of the attack on the judge was he was far too expansive or broad in his approach. And that, of course, only works if you say that it should have been a strict or narrow approach.
The word in connection with appears in Article 23.
Exactly, precisely. The only way, it morphs slightly in Powell Dufferin.
But we're applying Article 23.
Of course, and Powell Dufferin is not the article.
No.
But Powell Dufferin says that it means originates from.
Yes, exactly.
That's why
it's just another way
the phrase is used.
Precisely. It's another way of putting it. But in my learned friend's supplemental skeleton, the judge was criticised for not using originate from. And I can take the court to that, but just do it very briefly, because it's a very short point. But essentially, it seemed to us reading it to be a rather arid point, and possibly slightly pedantic. If we look at the, maybe we should look at the fourth core bundle, which we probably had out for the terms of the contract, and turn to tab 41, where my learned friend's supplemental skeleton appears.
Yes.
And you look at paragraph 37, for example, which is at page 1041. The judge is criticised for applying expansive interpretation. Now, that's a criticism that runs through, really, from paragraph 15 of the skeleton argument throughout. It runs through, essentially, to the judge's approach to Article 23 material validity, on every aspect of it. There is a criticism in relation to both the definition of the relationship and also the degree of connection that the learned judge applied. And in paragraph 37, there is a criticism of the expansive interpretation. And over the page, he's criticised for using the language of connection, which the skeleton says, oh no, connection only applies to the relationship between the EJC and the legal relationship. And then the judge says, however, the disputes must arise out of or originate from the contractual relationship.
But then what do you make of paragraph 31, which is conveniently of Powell Dufferin? See para 24 of this skeleton, where for ease of reference, we can just see what is said there by the CJEU, that the aim of the words is to limit the effect of an agreement conferring jurisdiction by ensuring any disputes originating from the legal relationship in connection with which the agreement was concluded, etc., etc. So
Yes.
how do you say we should read Powell Dufferin against the words of Article 23?
Well, I think one has to read Powell Dufferin as simply articulating the meaning of Article 23. They're not when they say originate from, they're not saying, oh, well, this is a very exacting threshold cross. Connection and arising from or originating from are all the same thing. Now the limit which is imposed is so that a party is not surprised. So, for example, going back to being run over in London by a Swiss director of the bank, I would be surprised, if not shocked, that I had to bring that claim in Switzerland. But in fact, that wouldn't arise because my claim would not arise out of the particular legal relationship that I had with the bank. So in a sense, it's the surprise element. It is not intended to impose any kind of a priori presumption against an exclusive jurisdiction clause. In Salotti, what we saw was the caution and the phrase strict construction in relation to the creation or the existence of the agreement itself. What's momentous about the creation of exclusive jurisdiction agreements themselves is that a party is foregoing the usual Article 2 jurisdiction. So something is being given up, and it's the same with arbitration clauses. You're giving up your right to be sued in your domicile. So there the court looks very carefully to see, well, has there been an agreement? Has there been consensus? And we see sometimes the very complex approach to what writing satisfies the requirement. It's on the back of the document, you don't know somebody's read it. But once the agreement has been formed, the strict construction approach of Salotti no longer has that particular role to play, which is ensuring that a party hasn't unwittingly, or by pressure of a more economically powerful party, given up a right to be sued in the place of their own domicile. So once the agreement is formed, in our respectful submission, the strict construction approach in Salotti, where the case was only about whether an agreement had been formed, is no longer relevant. Of course, one is looking to see that the material validity requirement is satisfied, but one's not looking to see whether it has been very satisfied in the sense of being worried about an exclusive jurisdiction clause on the back of the document that the party may have been given but may not have looked at. You're in a different ballpark, and the Swiss authorities are quite clear on this, that an arbitration clause is something the court looks at with some degree of close scrutiny to make sure that the agreement has actually been reached. But once you've reached that agreement, there's no reason why you shouldn't have agreed whatever you want to as being included within the EJC. And we'll see from passages in the Advocate General's opinions exactly how liberal an exclusive jurisdiction clause can be. So I can scroll back to my Lady Justice Carr's question as to whether one should read Powell-Duffin as requiring something special in originating from. We respectfully submit no. One's simply looking to see whether the matters in dispute arise in connection with a particular legal relationship. The work, if I can put it that way, the exclusionary principle that a court might approach an EJC with, has its greatest force at the point of analysing whether an agreement has been reached. But once the agreement has been reached, then you just need to you need to do a check that the matters in dispute arise from a particular legal relationship. But you don't need to work on the principle that it would be very strange if say, for example, let's take an example. I enter into a custodian agreement, and I enter into a contract which has an exclusive jurisdiction clause. I hold an asset on behalf of my customer. I pay that asset, I transfer that asset to a third party without authority, and no mandate. Now that clearly is a claim that would arise in the context of the legal relationship created by the custodianship account documents. Let's say I transfer the document to a member of my, the asset to a member of my family. Now, there would still be a perfectly straightforward case to make against me because there's no authority. Now let's imagine that I have a limitation problem, and I can only get round limitation by pleading fraudulent concealment, or that the transfer was fraudulently carried out. Or I may even plead that as an alternative to my simple, if I can put it like, plain claim, you did something without my instruction. Now, that claim based on fraudulent concealment or a fraudulent transfer of an asset to a third party, that would still come within the particular legal relationship in connection with which the EJC had been agreed, because it's part of the relationship. It doesn't suddenly come out of the agreement because it's fraud. And so in the same way, one can see that that originating from is not a way of excluding claims from EJCs. It's just a way of checking that I don't, having been run over on the zebra crossing in London, have to bring my claim in Geneva. I mean, that's an extreme example, but and you also gave the example of falling downstairs on the way out of my solicitor's office.
This case is a step removed from that example because none of the monies pass through these accounts.
Well, my lady, in our respect for submission, that's not the point. The point in this case is that the contract was formed, investment products were acquired through Mirabeau, which were sometimes recommended to Mr. Al-Rajaan, we can see that. And then Mirabeau would acquire those investments. Those investments would then generate a number of different payments. So, for example, if I buy shares in a fund in Cayman, the prospectus may well show that the investment manager will take a 4.5% fee out of the investment. Now, that money is then often distributed by way of commissions to introducers, and in this case, it was what Mirabeau did when it was instructed to get the particular investment that generated fees, both on the creation or the acquisition of the investment, and then also in returns on the investment, and possibly other fees to the manager paid on the basis of the value of the fund every year. So it doesn't really matter where the money goes in our respect for submission. It matters what was done to create the stream of commissions that then form the basis of the A and B claims.
I'm just mindful of
course,
shorthand writing.
Yes.
And appreciating that time is precious. We'll rise now and return in 5 minutes.
Thank you very much. Oh, thanks. That's very good.
Get an out. Yes. He didn't raise this.
So far, very much so good, Francis.
Good.
Particularly hitting all the right spots, isn't it?
Yeah.
It's all right. You're off. Because what you've got to
All right.
My ladies, just before I move on to the underlying facts, if I may, and I'll deal with fairly briefly. Obviously, the court has in mind what we were looking at from the general report. That these, oh, I'm so sorry. It's a great relief. It's like not wearing your wig. It's becoming quite problematic.
I thought something had gone wrong, but
I thought something had gone wrong too, but I always assume something has gone wrong. But just as general background point, autonomy of the parties is important, and the Brussels regulation and Lugano follows that. Autonomy is important, and these rules are supposed to be predictable. But I think what follows from that, in our respect for submission, well, I don't think I'd submit, but what follows from that is that a party and the court should be able to tell pretty quickly, is this within, is there a jurisdiction clause, is this matter in dispute one that arises in connection with the particular legal relationship. These are not intended to be
Fine points.
fine points or sophisticated points or semantic points. They're reasonably broad, and of course the courts rightly always say, and possibly will say in this case, it shouldn't be necessary to have thousands of pages of documents in order to be able to do this exercise. Of course, I'm only taking an hour and a half, so there we go. But this whole point about
4 days before the judge.
yes, we had a lot of Swiss law, my lady.
No, I understand that.
About 20 livre arch files
Yeah.
of Swiss law.
20 livre arch files.
Something like that. The unvisited F bundle.
And the unvisited supplementary bundles here.
Oh no, we'll get to that, my lady. No, I'll try to. I'll try to
Don't
make
visit them if you
No,
don't need to.
I won't do it unless I need to. Absolutely. But we've also seen in Advocate General's opinions this flexibility. And I'm going to give some references, if I may, without going to them, just because it's interesting to note that against the background of strict construction, there is a degree of relaxation about how broad a party can agree the scope of the jurisdiction clause, because that's entirely consistent with the respect accorded to the autonomy of the parties. So in Benincasa, the Advocate General deals with the fact there's no objection in principle to a widely worded clause, and that's at Authority Bundle 4, tab 41, pages 1384 to 1385, in paragraph 66.
Sorry, your voice keeps
I'm
dropping.
so sorry, my lady, that's my fault.
AB.
It's Authorities Bundle 4,
Yeah.
tab 41. It's pages 1384 to 5, and it's paragraph 66b and 7. We've already seen what the Advocate General said in Apple, paragraphs 56 and 57, which are Authorities Bundle 5, tab 52, page 1755. Also, which is paragraph 56 and 57, there's also paragraph 71, the Advocate General uses the word linked. So again, just going back to the point that connection is connection, whether you use a synonym for that, doesn't change what we're looking for. In the Gennard report, which is at Authorities Bundle 6, tab 59, Article 17, the precursor of Article 23, is dealt with at pages 1977 and 1978, and they are focused on the need to be sure there's an agreement. Nothing is said there in particular stressing the requirement for strictness. And so, by way of coming back to my beginning, when I respectfully submitted it, I thought it was strange during the course of the opening of the appeal that we were going through so much of the judge's judgment on material validity and finding nothing wrong. And my Lady Justice Simler pointed out there were omissions, but the omissions in particular were the absence of due regard to the admonitions of strictness, so what I would call the strictness mantra, and then the other criticism in particular was that out of the strictness mantra there was an insufficient regard to the existence of consensus. We respectfully submit consensus is done by the time we've got the agreement, and we do have the agreement in this case, there's no issue on that. And then the other
Did the judge refer to Benincasa?
he does refer to Benincasa.
Yeah, just give me the paragraph.
I think we've found it longer.
Don't worry, carry
Can I
on.
ask,
Carry on, we'll
Mr.
find it.
Singler, just to look at that.
Yes, thank you.
It does crop up. And then the other omission was the...
102.
Thank you very much, my Lord. The other omission was the failure to apply what was called the CDC analogy. And I'll say a little bit about that in due course. We respectfully submit there is no analogy with CDC on the facts of this case, because that comes slightly back to the issue which Lady Justice Simler raised with me, which was that the money didn't go through the account. In our respectful submission, the acts which are complained of are very much to do with the conduct of the relationship by Mirabeau with PIFs. And it's not, in our respectful submission, good enough. And my learned friend used the phrase money in and money out, I think was the way he put it. And he said, well, money out is what goes through the offshore accounts. In the case of Banque Mirabeau, it's alleged with Overton. So those are the disguised accounts that route money. Now, there would be no claim without money in. Money in was generated by the conduct of our clients, as alleged, of the banking relationship with PIFs, because that's where the money came from, which then went down the money out system. So for the secret commissions, for A and B, one is looking at two parts, because if in 1995, 1996, the offshore accounts had been created, but no, they hadn't been used for the payment away of secret commissions as alleged, there's nothing to complain about, there's no issue. It's only when you put the money in that you generate the sums of money to which Bruce then makes its claims. So in our respectful submission, it can be quite clearly seen that this case is very different from the case of a cartel which had been created between producers maybe many years before the particular supply contract which arose in the case of CDC or in all the claims in CDC. That cartel is entirely separate. The court took the view that the claims of a consumer in relation to the supply contract were not covered by the exclusive jurisdiction clause because the cartel was not linked to the contract. In the other situation in Apple, it was the performance of the contract by charging too much or by distributing selectively or whatever. It was actually by performance of the contract that the claim arose. So one sees immediately that this in our respectful submission, and I'll develop it a little more if I have time later, but this is a much more like an Apple case because it's the performance, it's the conduct of the relationship which generates the claim. Because the claim is generated by the fees which arise on the acquisition of investments or the purchase of limited partnership interests or shares in funds. And then it's the money out, the payment of those fees, which is described as the secret commissions and A and B. So in our respectful submission, the CDC analogy just isn't an analogy. As my Lady Justice Simler said, the judge described it as an illustration. Well, that's fine, all these cases are illustrations that we've looked at. But it's not an analogy, and the fact that the judge didn't apply by analogy with CDC to this case, for the purpose of reaching a conclusion, there was no link between the claim and the legal relationship. And there was no error in that. That was exactly correct. If we can very briefly look at the supplemental bundles at SV4, and I'm not doing this just for the sake of it, but it is, I think it is helpful, and I can take this really very quickly. Because it I think flows back my Lord Justice Peter Jackson's point, which is that when you've got these clauses, you're not looking at the beginning and saying, well, that's the only viewpoint. You're looking at the whole period, and of course here you've got exclusive jurisdiction clauses that run throughout. So you're looking at the whole picture. And if I could ask one of my ladies to look at tab 10.2 and page 1169. So would you, Court, just give me a moment? So if I can just take myself back very briefly. No, we can look at 1169, I think. Just so we can orient ourselves. 20th of January 1997. This is the genesis of the contract, the application forms for the opening assent. And then all the contractual documents which then arose. We can see the signature card at page 1173, and we can see it at 1176, and the court would be good enough just to look at 1177.
What are we getting from this?
What we're getting from that is that the signatures are valid for all present and future relationship. It just goes back to the point. It just shows us in real form what we saw in that document at Core Bundle Volume 4, tab 35. Yes. I don't think we need to look at any more than that. So we've got the contract starts on the 20th of January 1997. The documents are all signed by Peace. If I can then ask the court to look at Supplemental Bundle 2. Tab 8.3 and page 612. So the contract opening documents all signed. Peace has signed the signature card, got the GTCs, the EJCs in place, and the ink is barely dry on the contract before an instruction comes in from Peace, asking, addressed to Pierre Mirabeau, asking Mirabeau to invest
Sorry,
10.
page?
I'm sorry, 612.
Thank you.
So, what point is being made with this?
It's really just to show immediately what was the contract was entered into, instructions were given, and Mirabeau was acquiring investments. It's really to make good the point I was making in answer to my Lady Justice Simler's point about how the money was generated. I can take.
No, I just have a level of anxiety because there's quite a lot to I think you want to get through in the next half hour.
Yes. Well, what these documents show, I will speak to them and just give the reference.
I'm very happy that you just give us references.
Yes.
Which we can then take ourselves to, because actually looking at the documents themselves don't actually
Fine.
tells you that much, frankly.
I'm very happy to take that course, and I'm being squeezed. Not by the court, but simply by the exigencies of the timetable. So 612, 613, two orders to put 20 million Swiss francs, well, $10 million and 10 million Swiss francs into two funds. Just for reference, one of the funds is Columbus Holding. Page 589 is the offer document, and one can see the fees generated on that at pages 593, 595, 596, and 599. One gets exactly the same with links. That's page 613. We don't need to look at the offering documents. It's very much the same methodology. Can I just very quickly ask the court to look at page...
My 593 is prospectus.
Yes, that's, I mean, the point of looking at the prospectus is only just to see there are elements in the prospectus where there is mention of fees being payable on the amount invested. Right. And the only point I'm making there is that that's the mechanism. Out of $10 million that goes in, an investment manager will charge a fee of 4.5%. That 4.5% and then annual payments on the performance of the fund, etc., are what generates a fund of money, if I can put it this way, that then starts a flow. The case is not pleaded in sufficient detail against Mirabeau for us to be able to see exactly how it's said that flow, the constituent elements of calculation of it, and so on. But it's just to show the mechanism. It's to show the money in point. That's where the money comes from, and it then goes out through the offshore account. So the reference in the prospectus are only to points where percentage fees are being taken. Nothing else. We don't need to look at that for any other purpose. But I just thought, having made that point, I ought at least to say where it is one can find that. Page 637, just very quickly, this shows Mirabeau recommending two Mirabeau-related funds, SICAV Europe and SICAV Multitech. And the point I make out of that is just to neutralise a point which my learned friend made, that he said there's no advisory contract, there's no investment management contract, therefore there's nothing but a bare account holding contract. The way the judge put it was that Mirabeau provided access to funds, the PIFs, and made suggestions, and here we see that in action. The judge was absolutely right in his conclusions. They were firmly based on the evidence. So in our respectful submission, what those documents show is that in his description of what Mirabeau was doing in the conduct of the relationship with PIFs, which he sets out at paragraphs 330, 333 to 336 of the judgment, justify the conclusions that he reached in paragraph 340. And in our respectful submission, and under pressure of time, I've slightly taken myself out of order. If I can just ask the court to go back to paragraph 227. 227 to 232, we see the judge referring to the critical terms and conditions for the purposes of defining the legal relationship. And he says it's paragraph 228, the parties' legal relationship forming part of their present and future banker-customer relationship. 228. And then in relation to all those terms, what he says is that they are agreements that created the relationship of banker and customer. Paragraph 230, third line, and paragraph 232, last three lines. And having, for the purposes of the judgment, there is no issue taken with the judge's review of those various contracts. There is, in our respectful submission, the can be no issue. The judge was right to look at all the terms of the contract because they were all relevant to the relationship which had been created by the contract as it was then conducted by the parties.
Do you have any comment on the need to go into this level of detail in order to decide a jurisdiction dispute? I mean, it just seems to me that,
Well,
regardless of the sums involved,
yes.
to have to write a 150-page judgment to deal with this sort of issue seems very burdensome
Yes.
on a trial judge. It's to the judge's entire credit that he anatomizes these documents to such a degree, but is it really necessary?
Well, I respectfully agree
Except
with
to
you.
withstand
With your lordship's
appeals.
comment, the judgment is a labour of Hercules. I mean, he has.
Well, it should. I mean,
Should it be?
Not all judges are Hercules, and they
Yes.
can't expect to labour on every single case of this kind. And I mean, it just strikes me that the level of minuteness with which this is being analysed
Yes.
is not really within the overriding objective.
Well, in our respectful submission, as a defendant who is, we respectfully submit, wrongly joined to English proceedings, Peace would have known there was an exclusive jurisdiction clause. They have lawyers in Switzerland, they have lawyers in London.
No, I'm not talking about the substance of it, I'm talking about the process. Should judges really be expected to comb through this sort of documentation with this level of detail in order to reach their conclusions, or is something a little bit more proportionate not likely to be adequate?
Well, it would be entirely within the court's power to introduce a discipline into these
Right,
applications.
well,
I think the court
as I
does
say,
that.
I just raised that
Yes.
as something that's going through my mind, looking at the sheer number of quotations that the judge is taking out
Yes.
of the individual documents
Yes.
in order to justify a conclusion. But I don't want to
No, and I
obstruct
won't.
your progress.
No, but the dynamics of these cases tend to be one is always on the edge of a clause, or at least it is argued that one is on the edge of being outside or inside. And so a lot of time is spent working out where the line is. In our respectful submission, if one takes a simpler approach, one says, well, what are these claims? What are you complaining about?
But I understand that,
Yeah.
that the parties may need to argue it
Yeah.
to this level of detail, but when the judge comes actually
Yes.
to decide it, I wonder whether
Well, I think
it's what we should be aiming
Well, I think the difficulty is the judge has all this material placed before him. If he doesn't deal with it, he'll be criticised for that. And if he does deal with it, because there was so much, I mean, for example, there's about 20 pages of Swiss law analysis, meticulous analysis, not appealed, not the subject of an appeal before this court. Your Lordship makes a very powerful point. But in our
I
respectful
think Mr.
submission...
Sinclair may want to
Sorry?
say. I think Mr. Sinclair may have a point for you.
Well, it's a very good point made by those behind me, much better than one I could have made. Which is why this court only does a review and not a rehearing. Essentially, one is looking at the judgment. Of course,
It was really rather that when we were getting into the documents, I'm
Yes.
thinking we're concerned with the judgment, we're not concerned
Yes.
with the documents that underlie it, unless somebody is saying that the judge
you're
is
also
wildly
right.
off piece.
Yes. The supplemental volumes have, so far, I don't guarantee it served their purpose so far as we're concerned. But where we end up is with the pleadings on that basis. And if I can invite the court to look at the pleading which is in Core Volume 3.
So we're now in the second section of your submissions.
Yes, we are.
Pleaded case.
I'm afraid slightly truncated. Having set out a roadmap, I then failed to follow it. But that's a slightly did a U-turn to get to the relationship. But those key passages in the judgment, 227 and onwards, and
Yes.
the passages at 313 in that section, and the conclusions at paragraph 340 are completely solidly based on the material before the judge. So far as the claim itself against Mirabeau is concerned, I think one can go straight to paragraph 79.
Where are we?
We're in Core Volume 3. And we're on page 619. And the scheme itself, and why one can see that it's, in our respectful submission, obvious that these claims arise from the banker-customer relationship, is that the scheme which is alleged to found this claim involves these two elements, which I've already described, as the money out, which is 79A, which was allegedly in place before the account was opened, and then the money in, 79B. And what Beef says is that these secret commissions arose in relation to investments that Mr. Al-Rajaan would authorise Peefs to make. So Peefs was making all these investments through account 507.750. It's said by Peefs, well, only 11 of them were held in the custodian account and 17 were outside, but they were all acquired through Mirabeau. There may have been all sorts of reasons why it was convenient to hold them in a custodian account or in some other nominee account. But the point is they were all acquired through Mirabeau. So they're all part of what gives rise to the basis for the claim, which is the activity in 79B. And then one can see paragraph 86, the custodian account was opened. And then one can see what flowed out of that was the commissions totaling $79 million. And one sees at 99 that the payments which are referred to in the previous paragraphs were made at the direction of Mirabeau, and that they totaled the $78.9 million. And then at paragraph 111, we've got the accessory claims. So in our respectful submission, one only needs to look at the claim, really glance at the claim, to show that these claims clearly arise from the banking relationship. Because unless the investments had been acquired by Mirabeau on the instruction of Peefs, there would have been no funds generated which could then have been allegedly paid through the offshore accounts. And so that's the A and B claim. And then the C claim, the court will be familiar with how the C claim works. The C claim is simply spelt out as being 111A is the B money, and then B to G are the C money, which I'll deal with briefly at the end of my submissions. So in our respectful submission, one has absolutely clearly the legal relationship in connection with which the EJC is agreed. We've looked at the documents, possibly in too much detail, but we can see where the judge got, what the judge founded his conclusions on. We see that the relationship was a banker-customer relationship. And it covered a wide range of different terms, which are set out in the section of the judgment where the learned judge identifies the relevant legal relationship at 287, 289. And then we see 227 to 232 is the legal relationship, and then we see his conclusions at paragraph 340. And on our respectful submission, there's just nothing wrong with them. That was why it was so telling when my learned friend was being taken through the document, through the judgment, there was nothing wrong except for the absence of a strictness of approach, which we say is not a good point. In fact, it's a bad point. And then the failure to, in some way, apply the CDC analogy. And just one point on CDC, if I may, is the language of foreseeability in our respectful submission provides for things to be lost in translation between EU law and English law, because we think of foreseeability as very much an element of causation. And then tracking back, one asks oneself, or one runs the risk of asking oneself the question, well, was it foreseeable that these claims would arise? But in our respectful submission, that's not the right question. What one needs to ask is a claim of this kind one that could arise out of the particular legal relationship in connection with which the EJC is agreed? So in a banker-customer relationship, all sorts of claims could arise. It's not a question of, well, it's only the things that I as a customer can foresee. It's the things that can happen. And just going back to the submissions I made earlier, of course, with a custodian account, you don't foresee that your assets are going to be paid away negligently or fraudulently. But it happens. And the claims which those events would generate are claims which arise in the context of the banker-customer relationship, in the context of the custodian agreement. So the question is not, could I foresee that secret commissions would be generated and paid to my investment manager in the way that was done? It's, if I've got a complaint against the bank for its conduct of the banking relationship, is it foreseeable that I will have to make those allegations and litigate them in Geneva? And we respectfully submit it is foreseeable, because they arise out of the relationship you have. You've agreed in relation to that relationship. Disputes will be brought before the courts of Geneva. And so when you start your claim, there is nothing surprising at all that you would bring your claim in accordance with the EJC. So the foreseeability word in our respectful submission creates the risk that English lawyers are going to go down a route which isn't promising in the context of...
Foreseeability and surprisingness have a great deal in common, and neither of them is the test. No. And your Lordship asked an important question yesterday afternoon about, well, is it a... It seems a bit subjective, but in our respectful submission, if one looks at the foreseeability or the surprise test in relation to these claims, if as a customer I want to make allegations that the banking relationship I had with you, Miabo, was conducted fraudulently, is it surprising that those are claims which I will be taken to have agreed should be brought in Geneva? Yes, no, I was tempting Mr. Beard with whether there was some category whereby outrage should be something that one would take one outside an exclusive jurisdiction.
Yes.
And speaking of myself, I haven't yet heard where one would draw the line if that was the case.
I suspect, well, I mean, obviously you have things like extirpa causa, which is a way of illegality. But in our respectful submission, if you agree in the context of let's say for example, you agree with your bank that they will have the conduct of your affairs, and something goes wrong with the conduct of those affairs, it may go quite wrong, negligently, it may go very wrong, recklessly, or even fraudulently. Or you may have to allege fraud because you need to get around limitations. Those are all going to be matters in dispute which will arise from that legal relationship. The point at which one could say somehow that the exclusive jurisdiction clause self-destructs because the claim is too hot for it to handle. Well, in our respectful submission, that would not respect the autonomy of the parties. Effectively, the court would be saying, well, you may have agreed that's what it looks like, but you can't possibly have meant to agree. That in our respectful submission, is not how it works. And so far as the breadth of clauses, I don't think I need to take the court to Apple at 56 and 57, but it's just very helpful to show that the parties are free to agree something very broad. The fact that it's very broad doesn't mean that it somehow offends against the material validity provisions of Article 23. I'm not sure there's anything I can really take any further on CDC and Apple. In our respectful submission, they are just two different cases, and we don't need to get too excited about whether the learned judge distinguished CDC or considered it. He was not bound by it to apply that analogy. We respectfully reject the criticism of the judgment as taking too expansive an approach to the material validity questions, because there is no too expansive an approach to take. The approach one takes is to say, well, what's the legal relationship, and is there a connection? And if there is, that threshold is then crossed, and one then ends up having to ask oneself the question whether under domestic law the relevant dispute comes within the particular EJC. My lords and my lady, we deal with the particular grounds of appeal in our skeleton argument in reasonable and I hope helpful detail, paragraphs 48 to 62, and that's in Bundle 1, tab 13. I'm not sure I need to take, unless there's a specific point that arises, I need to take your lordship and your ladyships to that, because it really makes probably rather more elegantly and better the points I've been making orally.
So these are the paragraphs on Article 23 material validity?
Yes, yes. And they deal with grounds 3 and grounds 5 of the notice of appeal, and they deal with effectively issue 2. And we respect this. And all the criticism that is made of the judge is without foundation, entirely unjustified. The conclusions are firmly based on the material before the judge, and this court, in reviewing it, in our respectful submission, has been given no material on which it could be persuaded to take a different view. All that's been said is he should have been a bit stricter and he should have paid more attention to CDC. In our respectful submission, both those points are flat. They, in our respectful submission, don't work. It is, in our respectful submission, very hard. My learned friend found it very hard to determine where in the judgment the judge had gone wrong. And subject to one point, if I may just turn my back. Sorry. And just before I leave material validity, can I just remind the court, paragraph 182 of the judgment. Where the judge sets out the terms. 182 subparagraph 2, dealing with the 1997 terms. All relations between the clients are subject to Swiss law.
1987.
This is in 1997. Each subparagraph is a different set. So 1987 is the one that we found going back into the archive. 1997 is the one is number 2. It's the one that PIEF's had on its file.
Yeah.
So yes, we have. And these terms are set out in CB3 at tab 35. But it's all relations, so in our respectful submission, it couldn't be wider, and that's absolutely fine. Rather cleverly done this. Can I deal very briefly with the accessory claims, and that's with the respondent's notice?
Yes.
The key reasoning on these claims, which he called the accessory claims, that we're talking about C, is at paragraphs 351 to 356. And the judge sets out at paragraph 352, the submissions that we made. Just so that we can orient, can I ask the court very briefly to take up again the consolidated particulars of claim?
I'm sorry,
Sorry,
I can only...
it's core 3.
Yes, but why have we gone to 351?
351 in the judgment is dealing with the accessory
Yes,
claim.
is there anything, apart from identifying where it is there anything about it you want to say?
Well,
or
really just to make this point, in little 3, the learned judge identifies that one of the arguments we made was that the claims in relation to the other unlawful schemes are based on knowledge acquired by Mirabeau, obtained as a result of the relationship of banker-customer in the period from 1997 onwards. And essentially what is alleged in relation to the accessory claims, which are, of course, somebody else's money going into somebody's account held at Mirabeau, not generated by anything Mirabeau has done in relation to the
Or a
banker
conduit.
relationship. Exactly. It's effectively using the money
knowing
out.
conduit?
The money out system has been used for other people's
Yes,
secret
yes,
commissions.
all right. Why do we have to go to underlying documents for this?
The only underlying document I was going to ask the court to look at was the way the case is pleaded, just so that one can see that the accessory claim cannot be made. If you like, the legal theory of the accessory claim is that Mirabeau's liability under the C money is premised on its knowledge that the C money is the product of unlawful secret
I
commissions.
think that's what he says,
Yes.
and he gives us the references.
Well, maybe we
which he
can
then
do
quotes.
that.
Yeah.
But the legal theory of the case, Peace accepts it cannot get this claim off the ground unless it can say that Mirabeau knew the money being paid into the various accounts was, if I can put it this way, the product of secret commissions.
But
paid.
essentially, I mean, it's that you were freelancing. So, I mean, the difference is that this wasn't your core business, as it was with A and B, but this is just a...
But the thing that, yes, the thing that changed that money from just being money being paid from outside into, say, Mr. El Ghazi's account, is that we knew when it hit Mr. El Ghazi's account that it was hot,
Yes.
if I put it that way. The only reason we knew it was hot, or money to which Peace could make a claim, was because of the Mirabeau scheme. So in order to get the accessory claim to work, Peace has to prove the Mirabeau scheme. So what we were submitting to his lordship is that connection, if you like, to prove the accessory claim, you had to prove all the facts of the banker-customer relationship. And so by that connection, by that connective tissue between
Yes.
the secret commission claim and the accessory claim.
Yeah, I think we've understood the question.
Yeah, absolutely.
I mean, I think probably we need to look at the judge's answer, David.
Well,
It comes
if we look at
following
the
your-
judge's answer, we see he said, paragraph 354,
Yes.
he said the general point made in 323 above applies, but he says it's only partly based on the Mirabeau scheme. He says there was also knowledge of the man scheme. Now, in our respectful submission, the knowledge in relation to the man scheme, which the first payment in relation to which didn't arise until 2001, Mirabeau could have had no knowledge that the man scheme was a secret commission
So where's the
engine.
man scheme referred to?
The man scheme is referred to in particular claim. It's an entirely separate scheme.
In the judgment,
It-
what's it referred to?
354.
354. Does the ladyship see?
Yes, I do, thank you.
He's saying, well, the accessory claim is based partly on the knowledge involved from the Mirabeau scheme, but also from participation in the man scheme. He does say other matters, but he doesn't say what they are. But in our respectful submission, knowledge of the man scheme cannot be, if I can put it this way, guilty knowledge for the purposes of the accessory claim, unless you've got knowledge of the Mirabeau scheme, because otherwise, the money coming into the various accounts held at Mirabeau by third parties would not be known to be money paid as a result of fraudulent secret commissions between Peace and third parties. So it was no answer to our point on the knowledge of the Mirabeau scheme being an integral part of the legal theory, so far as accessory claims were concerned, to say, oh, well, it's not just a Mirabeau scheme, it's a man scheme, because the man scheme knowledge would itself be dependent on the Mirabeau scheme, because otherwise the man scheme would simply be another source of money being generated, which was being run through accounts in Mirabel, but money being generated between PIFs and third parties other than Mirabel. Right. So if I can put it this way, the narrow point we take is that in rejecting the connection, the learned judge said, oh no, that's not enough because you've got this other source of knowledge, so the legal theories are not aligned. But in our respectful submission, it just doesn't work because you don't get any knowledge that the man scheme is a conduit for secret commissions unless you've got the knowledge.
So the judge drew the line in the wrong place.
Exactly. My lord, my ladies, you've been very patient. Those are our submissions. Thank you very much.
No, thank you very much for compressing your submissions in that way, Mr. Trigger. Right, Mr. Jard.
May it please the court, I appear for Mr. Mirabeau with my junior Blakely. I gratefully adopt the submissions of Mr. Tregear from Mirabeau Bank and Mr. McLean in relation to the issue of material validity and indeed construction. And I gratefully adopt also the submissions of Mr. Adkin, QC, on the point of principle in relation to the interpretation of Article 6. And I wish to address you only on two short points, and I hope not to detain the court very long. And those two short points relate specifically to Mr. Mirabeau's position.
All right, well, sorry to obstruct you in this way, but at some point we'll take a second break of the morning for the benefit of our transcriber. Would it be convenient to do it either now or after you finished, which is?
I'm very content to do it now.
All right, let's do that. Thank you very much.
Yes.
Chan again. Oh, of course you're.
I'm on the other side.
I lost the bundle in the course of time. It's very funny how that happens. You kind of keep putting it in the wrong place. I have a bundle with dematerialised.
Yeah, this is the judgment.
It wasn't good.
Is that all right? All right. We have more copies than you can understand of that particular document. No, you can.
Yeah. Do you want to?
All my folders.
Thought that occurred to me arises from death.
I don't think
It's okay, it's not in my way. It might be quite useful for
Another desk.
How you actually make
I think I probably did. Yes.
it says there's muscle there, but it's all tied up.
It's funny what you
Court ready? Silence in court. Court rise.
Yes.
My lord, my ladies, I said I had 2 points, and just identified them. The first point relates to the application of Article 6 to Mr. Mirabeau, which is specific to him, but also in our submission illuminating when it comes to Article 6 more generally and the proper approach to it. And the second point is the one that we raise in our Respondent's notice, which is issue 5.1 of the listed issues. And that only arises if we are wrong on the point of principle in relation to Article 6. Now, before I come to those points, by way of background, it's necessary to focus in a bit on the particular position that Mr. Mirabeau is in, and what Lady Justice Carr, I think, called the Mirabeau wrinkle, Mr. Mirabeau wrinkle.
No disrespect was intended to anybody.
If I could just remind the court of the essence of the position, which one can pick up from the judgment at paragraph 377, which is on page 448 of the judgment. The judgment, of course, being in tab 23 of the second court. And you'll see there that at paragraph 377, the judge sets out the central allegations set out in the particulars of claim against Mr. Mirabeau, namely that between 1997 and about the 8th of May 2012, a total sum of $76.9 million was paid by way of secret commissions to Mr. Al-Rajaan in respect of 28 investments by PIFs. So that is the fundamental allegation. And you'll see over the page in paragraph 379 another important salient fact where it notes that although Mirabeau wasn't incorporated until 2013, Mr. Mirabeau retired from being a partner on the 31st of December 2009. So what that means is that for the 13-year period in 1997 to the end of 2009, he was a partner. But then for the last period of 2 and a bit years, 2010 to May 2012, he was not a partner. And we see that in paragraph 380, the judge then goes on to note that 24 of the investments or payments listed in the particulars of claim as being related to the Mirabeau scheme were made by PIFs between the 10th of February 97 and the 16th of November 2009. And they account for 86% of the investments by number and by value. And the other 4 investments that were made after 2009 account for just 14% in number and value. And then moving on to paragraph 381, he notes that it's not alleged that the 4 post-2009 PIFs investments had any different characteristics from the 24 pre-2010 investments, or that they formed part of any different scheme from that alleged to have been agreed between Mr. Al-Rajaan and Mr. Mirabeau and Mr. Fauchier-Magnon by the 20th of January 97. And no specific act of Mr. Mirabeau is alleged to have taken place after around 2005, save that PIFs pleads knowledge gained by Mr. Mirabeau prompted the termination, and others, prompted the termination of the Silbury Bay Agreement in 2012, and PIFs makes the broad general allegation that payments spanning a period of that 15-year period between January 97 and May 2012 from Galmere to Silbury Bay were at the direction of Bank Mirabeau acting through Mr. Mirabeau. So then, as we see in 382, he concludes it's not alleged that any new or distinct scheme came into being at any point from the 1st of January 2010 onwards. So that's the background. Now, on the judge's findings as to the scope of the Swiss exclusive jurisdiction clauses and his findings on material validity, Mr. Mirabeau can rely on the Mirabeau Bank exclusive jurisdiction clause to cover the secret commission claims, so the court's categories A and B, for the period when he was a partner. But the judge also found that Mr. Mirabeau's reliance on the exclusive jurisdiction clause was limited in 2 respects. First, of course, like all the other relevant Mirabeau defendants, the judge found that he couldn't rely on them in relation to the pure accessory claims, the court's category C. And for your note, you'll find that in paragraph 11.3 of the judgment in relation to Mr. Mirabeau. And I adopt
11.3.
11.3. Now I adopt my learned friend's submissions on that. I don't propose to go through that again. But secondly, and this is the point we're concerned with, the judge also held that for the period of time after he was a partner, he couldn't rely on the exclusive jurisdiction clause even for the secret commission claims. And for your note, I don't think we need to go to it, that's at paragraphs 383 to 385 of the judgment. I may need to come back to that if I have time in relation to the respondent's notice. But stepping back then, where does the judge's findings leave one? Well, it means that on the one hand, the claims against Mr. Mirabeau for the Mirabeau scheme secret commissions in respect of the first 24 payments over the first 12 years will have to be brought in Switzerland, in the judge's findings. But on the other hand, the judge's findings also meant that Mr. Mirabeau couldn't rely on the exclusive jurisdiction clause in relation to the last 4 payments for the 2 years and a bit when he was not a partner. And that's a point of construction that I'll come on and we do challenge by way of the respondent's notice. I'll come back to that in a moment. But the court doesn't need to trouble itself with the respondent's notice unless the claimants overturn the judge's finding that the post-partnership period secret commission claim against Mr. Mirabeau can be joined under Article 6. Because the starting point is that Mr. Mirabeau is domiciled in Switzerland, and so the default position is that he must be sued there on all claims, including that fragment of the claim that relates to the period after he ceased to be a partner. Now, the other side of that coin is that since he's domiciled in Switzerland, the claimants also have a right to bring that fragment of the claim in Switzerland, along with the main part, the earlier part, for the 12-year period. And for the same reasons, unless the claimants can rely on Article 6 to join the later fragment of the secret commission claim, they can't bring that claim here in London. They, in practice, have to do it in Switzerland, along with the bulk of the claim. So that's the background. And you've heard the debate between Mr. Beard and Mr. Adkin on the case law on the proper interpretation of Article 6. And tempting though it is, I don't plan to wade into that again. But I do want to highlight just this, which is that this is a, because I think what this point shows in my submission is the difference of approach in practice, in action. The judge held, on the basis of his interpretation of Article 6, that it would not be expedient for this fragmentary post-partnership claims against Mr. Mirabeau to be joined to the proceedings here in England. And one can see that, he comes to that conclusion very easily. Again, we can see it in the judgment. It's at paragraph 462, which is on page 470. And he says, the issues between PIFs and Mr. Mirabeau, as regards the periods prior to and after the 31st of December 2009, including the issues relating to the knowledge of Mr. Al-Rajaan's alleged wrongdoing, are identical, or virtually identical, for the Swiss court to consider claims for the period up to that date, and the English court for the remaining period, would create a clear and obvious risk of irreconcilable judgments between the same parties and on the same issues. And so we say, well, this is a rather good test case against which one can test the claimant's theory, which is to the effect that in adjudicating expediency under Article 6, the court is obliged to have regard only to the connections between the claim against the anchor defendant and the claim that it is sought to join. Because it follows from that approach that the claim, that the fact that the claims against Mr. Mirabeau for the first part of the claim, in respect to the first 24 payments of the first 12 years, must and presumptively will be brought in Switzerland, is on the claimant's view completely irrelevant. It's something, they say, the court must just disregard when one then turns to consider whether it's expedient in the interests of justice for preventing irreconcilable judgments for the remaining part of this claim. The claim for the last 4 payments to be brought in England, along with the other claims brought here. So that's the inexorable logic of the claimant's argument, and they don't shy away from it. They say that the court is obliged to put on these blinkers and ignore the fact that a claim against the same defendant, Mr. Mirabeau, will be brought in Switzerland. And not only that, but one has to ignore the fact that it's essentially the very same claim, just relating to a different temporal part of it, that will be brought in Switzerland. And now in our submission, the position of Mr. Mirabeau illustrates rather starkly why it would be not just undesirable, but actually almost absurd to adopt the appellant's approach. Because it would positively cause fragmentation of the very same claim against Mr. Mirabeau. It would be a positive invitation for irreconcilable judgments.
There's a difference between fragmenting groups of defendants and fragmenting individual defendants because of the consequences.
Well, there is a difference, my lord, of course.
Yes,
but
the judge's approach has been to separate out groups, not to leave some with a foot in each camp.
Indeed, but if the claimant's approach is right, then they don't shy away from that. The logical consequence of their approach is that you would have to fragment self-same claim against the self-same defendant. Now the claimants can tacitly recognise, in a sense, the undesirability of that result in the case of Mr. Mirabeau, because one can see that from the fact that they actually concede that in relation to Mr. Mirabeau, if there were to be any sort of wider or comparative evaluative exercise to be done, they accept that on that basis, the claim against Mr. Mirabeau for the post-2009 secret commissions should be tried abroad. And you'll see that concession for your note in their first skeleton argument on this appeal at paragraph 61, which is in the core volume at tab 10, page 96. The same concession is actually made for Mr. Argon. Now, that's obviously a sensible concession, because it's quite self-evident that if, as part of the exercise of judging what is expedient, the court is entitled to cast even a passing glance at the world outside the claimant's hermetically sealed chamber containing just the two claims looked at in isolation, then the fact that the claims against Mr. Mirabeau on the main part of the claim against him are proceeding in Switzerland is just obvious, makes it just obvious that it would be wholly undesirable.
Sorry, I can't find the concession. My fault.
my-
Bundle
my-
1.
It's in Bundle 1, tab 10.
Yes.
According to my note, it's on page 96,
96.
paragraph 61. Yes, it's the last sentence of paragraph 61. You see, they say that in that event, it submits that the court will also have jurisdiction over the claim for bribery against Mr. Amuzagar, but it is accepted that the claim for bribery against Mr. Argon and the claim against Mr. Mirabeau in respect of the bribes paid after 2009 should be tried abroad. So they don't pursue that, and obviously so, for the reasons I've stated. So, for all those reasons, we say that Mr. Mirabeau's position highlights rather starkly why, as a matter of common sense and good practice, the judge's approach to Article 6 is surely to be preferred. And the notion of expediency in the context of Article 6 must surely be an evaluative exercise that is not acontextual. The claimant's approach would achieve the opposite result of that which the Convention aims to achieve. Now, that is the first point I wish to address you on. If you're against us on Article 6, then the Respondent's notice point arises. I will try to deal with it very briefly. We say that on the proper construction of the jurisdiction clauses under principles of Swiss law, the part of the claim in respect to those last four payments do actually fall within the exclusive jurisdiction clause on a proper application. Now, appreciate that...
This was a finely balanced judgment.
Indeed, indeed. But there's also, there's also an inconsistency in our submission in the judgment. Because if you go to the judgment, first, Mr. Berterac is dealt with first. And if you go to paragraph, paragraph 369 in the judgment, you will see that from that it's on, forgive me, it's on page 446. And you'll see from that Mr. Berterac had essentially the same issue regarding liability potentially arising out of the period after he ceased to be a partner. And you'll see that the judge then quotes from the report of Professor Mabillard, a distinguished professor of Swiss law. This is the only Swiss law evidence on the point, because the claimants raised the point very, very late. And you'll see Professor Mabillard, you'll see perhaps I can just read the relevant sentence in paragraph 75, which is in which Professor Mabillard says that further, the jurisdiction clause covers any alleged liability deriving from the performance of an agreement concluded by a partner, regardless of whether the agreement is put into effect at a time after he has ceased to be a partner. In this sense, the partner may rely on the jurisdiction clause for any acts carried out in performance of this agreement. And over the page, at paragraph 370, the judge rightly concludes in relation to that the second proposition, starting with the word further, might relate to liability for actions taken by third parties. They might, pursuant to an agreement made by the partner while he was a partner, they might also cover payments made or other steps taken by the partner himself after he ceased to be a partner, pursuant to an agreement made while he was a He then, and the judge's reading is correct. The professor is indeed stating that acts carried out after he was by a partner after he ceased to be a partner will or may continue to be covered by an exclusive jurisdiction clause when they constitute acts in performance of an agreement concluded whilst he was a partner. And Professor Mabillard goes on expressly to say in the passage quoted by the judge that may also apply to an agreement to pay commissions. And he applies the judge applies that in relation to Mr. Berterat's position in paragraph, ultimately in paragraph 373. And he says, a jurisdiction clause may well apply to acts or omissions occurring after a party has departed, but which are closely related to the relationship that existed between him and the other parties prior to his departure. For example, in the present case, steps taken post-incorporation in order to implement or complete transactions initiated while Mr. Berterat was still a partner would be likely to fall within the scope of the EJC. I consider that Mr. Berterat has the better of the argument here, albeit that the point is finely balanced. And so on. So, well, I should go on. Assuming that the allegation pleaded in particulars of claim relates to Pictet scheme proceeds, it can reasonably be regarded as the last stage, so far as concerns Mr. Berterat, in the implementation of the concealment process alleged in paragraph 204 as a whole, and it occurred only a few months after Mr. Berterat's status changed from partner to employee. So the judge accepted that, as far as Mr. Berterat was concerned, he had the better of the argument that steps taken after he left the partnership to implement or complete transactions initiated when he was a partner were covered by the prior exclusive jurisdiction clause. But then when it comes to Mr. Mirabeau, he adopts a different position. And you see that in paragraph 385, just a couple of pages on. And you'll see what he says. Like the corresponding issue in relation to Mr. Berterat, I find this point finely balanced. However, I've concluded that Mr. Mirabeau doesn't have the better of the argument on this particular point. Unlike in the case of Mr. Berterat and Pictet, PIFs continue to make further investments, before referred to above, alleged to have given rise to secret commissions during a period of something approaching 2 years after Mr. Mirabeau ceased to be a partner. Although on one view this could be regarded as no more than further implementation of the alleged agreement originally made in or before January 1997, I don't consider the jurisdiction clause can be stretched so far as to treat the payment and concealment of new secret commissions over such a period as relating to the parties' pre-2020 relationship. I therefore conclude that the EJC doesn't apply to the post-2009 allegations against Mr. Mirabeau. Now, we say that, with respect to the judge, in this very brief reasoning, he has clearly erred, because the distinction that he draws between the position of Mr. Berterat and the position of Mr. Mirabeau is essentially an arbitrary one. It's based solely on the time difference in the two situations. Now, the evidence of Swiss law that the judge had before him, I've shown you, and it was uncontradicted. And it stated the principle that the implementation or performance of a previous agreement entered into when partner would be covered by the exclusive jurisdiction clause. And as the judge also recognised in the passages I've also shown in the judgment, there was no allegation or evidence of any different scheme after 2010. The payments made after 2010 were implementation of a single agreement or arrangement. So in those circumstances, applying that uncontradicted law to those facts, the court ought to have been consistent and ought to have concluded that the later payments were also covered by the jurisdiction. My lord, my lady, those are the only two matters on which I wish to address you, unless there's anything on which I can be of further assistance.
These are matters dealt with in your Skeleton Argument 51 and 52. The response
my lord,
right?
that is, I believe that is correct.
Yes. Well, thank you very much indeed, Mr. John.
Thank
you. Yes, Mr. Davies.
My lord, my lady, some brief points, if I may, on behalf of the 13th defendant, Mr. Fauchier-Magnon. You'll have seen from the papers his position is essentially the same as that of Mr. Mirabeau, except without the wrinkle. There's no post-partnership point that applies to him. The judge held that all the A and B claims against him fell within the jurisdiction clauses. Now, I'm not going to repeat anything that others have said, and I adopt the general submissions. The only point I was proposing to address is a topic that no one has really covered in any detail in oral submissions, which is grounds of appeal 9 and 10. And that is the argument on the part of PIFs that even if the judge was right on the interpretation of Article 6, he nonetheless wrongly applied it on the facts of this case. That's not been addressed orally by PIFs, but is clearly still part of their case on this appeal, and they refer to their skeleton. Now, dealing with that briefly, our submission is the judge was clearly right when you understand what the consequences would be if PIFs was correct in its application of Article 6. And the premise of the argument is, of course, that the Swiss court must decide claims A and B against the Mirabeau defendants. So that means the Swiss court will be investigating and making findings in relation to the establishment of the relationship between Mr. Al-Rajaan and Bank Mirabeau in the 1990s, and whether that relationship was an honest one. And that will include making findings of fact as to what meetings took place, who attended, what was said, the nature of the arrangements that were put in place, and so on.
Could I just check, we're looking at your skeleton argument at paragraph 50 onwards, are we, with regard to this particular issue?
It's essentially the last 2 pages of my
Thank you.
So all of that will happen in Switzerland. And if PIFs is right on the application of Article 6, the English court will determine whether the Mirabeau defendants are liable in tort for the C claims. So that's the laundering claims. Now, there are 3 crucial points in relation to that, the overlap between the A and B claims on the one hand and the C claims on the other. And in a sense, this is echoing some of the points made by Mr. Tregear earlier. The first point is the essential nature of the C claims is that some of the companies and accounts set up for the purpose of Mirabeau paying secret commissions also receive payments in connection with other schemes. Second, it's an essential part of the case that the Mirabeau defendants knew that the other payments passing through those companies and accounts were dishonest secret commissions. That's paragraph 114 of the particulars claim. And thirdly, and importantly, that allegation of knowledge on the part of the Mirabeau defendants is itself based on the allegation that the relevant companies and accounts were set up for the purpose of Mirabeau paying dishonest secret commissions. I.e., that the nature of the allegation is it said, because these companies were set up for a dishonest purpose, you, the Mirabeau defendants, knew that other payments passing through the companies and accounts must also be dishonest secret commissions. That's the nature of the case. And all of that is, of course, correctly summarised and understood by the judge in his judgment. Now, where that takes you is the effect of all that is in order to try the C-type claims, the C claims against the Mirabeau defendants in England, the English court would necessarily have to investigate the establishment of the relationship between Mr. Al-Rajaan and Mirabeau in the 1990s and make findings as to why the relevant companies and accounts were set up and whether it was for a dishonest purpose as alleged. And no doubt PIFs would say that extensive disclosure would have to be given in relation to that question in England, and it would seek to cross-examine Mr. Mirabeau and my client at length about those issues in England. So what you would get in England on PIF's case is effectively a trial relating to the facts, a trial of the facts giving rise to the A and B claims by the back door, because it's not possible ultimately to try the C claims without also making findings about the facts said to give rise to the A and B claims. And of course all of this would happen in circumstances where the relevant hypothesis is that the English court has ruled that the Swiss court has exclusive jurisdiction to try the A and B claims. Now, what's quite significant and important about this scenario, the scenario where PIFs is correct, is you have a very grave risk of 2 irreconcilable judgments from the courts of two Lugano states for reasons which are obvious. Essentially, two Lugano courts would be investigating and making findings in relation to the same set of facts. And there is therefore a risk that what you would have as the end result is irreconcilable judgments as to those facts and the honesty of the relationship between the very same parties. And irreconcilable judgments between the same parties of two Lugano courts must be the worst kind of irreconcilability of all, bearing in mind the general scheme of the Lugano Convention, and particularly bearing in mind the Mirabeau defendants of each.
Is this the point that I've been trying ineptly to articulate at various points during this
It's the same point.
appeal? But it's one thing to say that if the court in this jurisdiction and the court in Switzerland, let us say, took a different view of what had taken place, that people who are being sued in one place might consider that they'd done better than people who are being sued in the other place. It's somewhat another thing if somebody who's been suing in both places has to make sense of doing well in one place and doing badly in the other.
Yes.
It's a more striking example of irreconcilability.
Yes, there's a sort of scale of irreconcilability, and on the worst you can have must be two judgments between the same parties in relation to the same set of facts that reach completely different conclusions. That must be precisely the kind of thing Lugano is trying to avoid, and that's the very point made by the judge, because it's only on their case that that particular risk arises, that you have two judgments between the same parties that reach completely different conclusions. On our case, you don't get that, and the reason you don't get that is that all of the claims against the Mirabeau defendants are being determined by one court in one go, and that court can make a fully coherent set of findings in relation to all of those claims against all of those defendants. Now, just briefly, what's on the other side of the ledger in terms of what PIFS has said in their skeleton about the application of Article 6? Much of what they say in their skeleton is effectively an attempt to transform Article 6 on this construction into a forum convenience test, which is not, on any view, and certainly was not a forum convenience test on the judge's analysis. The approach they take in their skeleton comes close to saying, well, the overall centre of gravity of the litigation is in London, because so many defendants are here and so many claims are being tried here. Therefore, it would be most convenient to try the C claims against the Mirabeau defendants here too. It comes close to that. But that's not the right kind of inquiry under Article 6. Certainly not on the interpretation adopted by the judge. Yes, the word expedient allows the court to look at all the facts of the case in the interests of justice. But on the judge's interpretation, it has to be expedient to take jurisdiction in order to achieve a particular purpose. It's the crucial point. And the purpose is, of course, to avoid the risk of irreconcilable judgments. So it has to be expedient to take jurisdiction for that specific purpose. And the short answer is really the judge's answer, that you're not doing anything at all to achieve or even further that purpose by creating the risk we've just described of an irreconcilable judgment or two irreconcilable judgments between the very same parties. That's the answer to that. Now, that's all I propose to say, aside from one final point, which is, although what I've been addressing is grounds 9 and 10, and the application of Article 6, one might also think that what I've said is relevant to the interpretation of Article 6 in the same way as Mr. Jowl put it, since PIF's interpretation of Article 6 would essentially mandate and compel the unattractive conclusion that I have described. It would tie the hands of the court, essentially. I mean, that was the only result that could be reached. So that really tells you, It's another reason to suggest that their interpretation of Article 6 cannot be the right one. That's all I was proposing to say.
Thank you very much, Mr. Tate. Yes, Mr. Phillip.
My lord, my ladies, I'm going to make a few points, if I may, on behalf of Mr. Argan, who is the 14th defendant, and uniquely amongst the respondents, a lawyer rather than a banker. No role in any of the banks before you today. Can I first of all make 2 points about the scope of the claim against him and the appeal against him? The first is that the claims against Monsieur Argan are only primary Mirabeau scheme claims, not accessory claims. So there may be some debate whether they're A and B. It's not quite clear whether they bleed into A, but it doesn't matter, I think, for present purposes. They're A and B, or A and or B, but they're certainly not C. And I can see the court's got that point on board. And therefore, perhaps if I simply say that's made clear in paragraph 4 of the appellant skeleton, you'll have that for your reference. The second point is that grounds of appeal 9 and 10 are not pursued against Monsieur Argan, just as they aren't against Mr. Joel's client. So if the judge made no error of principle in his approach to Article 6, there is no challenge to the way he actually evaluated the facts and matters he was allowed to take into account, and therefore the appeal will fail as far as Monsieur Argan is concerned.
Is that the, just to make sure I've got that, is that because of the concession in paragraph 61 of the skeleton, right?
It's effectively the same point, my lady. Yes, that's right. It's also footnote 2 of the same skeleton. Taken together, that's the same concession. And as Mr. Joel said for Monsieur Mirabeau, that rather gives the lie to the absurdity of the outcome in this case, if Pips were right on Article 6, because there is no attempt to suggest that if the claims against the Mirabeau scheme defendants otherwise have to be heard in Switzerland, it would somehow still be appropriate for Monsieur Argan to be alone in London, having the claims made against him here. Now, can I then just...
Is that Mirabeau, Mr. Mirabeau, Mr. Argan, is that also Mr. Fauchier-Magnin, or is grounds 9 and 10 pursued against him?
Grounds 9 and 10 are pursued against Mr. Fauchier-Magnin, I think.
Thank you.
Yes. The difference is only because there's the rump or wrinkle point on Monsieur Mirabeau's case,
yes.
my lady.
Thank you.
So can I just briefly, and I hope I'm not going to tell you what you already know, but I'm not going to go to the pleadings and I'm not going to go to the judgment. I'm just going to tell you why the claim against Monsieur Argan is at least one further remove away from the anchor defendants in this court. Monsieur Argan is alleged by PIFs to have been instructed directly by Monsieur Mirabeau and Monsieur Fauchier-Magnin. There is no allegation at all of any direct dealings or communication or anything like that between Monsieur Argan and Mr. Al-Rajaan or any of the other anchor defendants who are being sued in London. That makes him unique amongst the respondents in this case, and that's why I say he's one step further away than any of them in this court. There's no evidence, I should say, incidentally, that Mr. Argan even knew of the existence of Mr. Al-Rajaan, or certainly his identity. So his liability, my client's liability, is said to stem solely from his role in taking instructions from Mr. Mirabeau and Mr. Fauchier-Magnin and acting on those instructions, which the claimant says constituted some kind of assistance in their procurement of secret commissions for Mr. Al-Rajaan. So the bottom line there, of course, is it's obvious. Mr. Argan can't be liable unless Mr. Mirabeau and Mr. Fauchier-Magnin are liable. Their liability is a sine qua non to my clients. So in order to try the claim that's made against my client, the court is going to need to know what my client knew and understood from his communications and dealings entirely with Mirabeau and Fauchier-Magnin, because he didn't have any dealings with anybody else, and certainly not Mr. Al-Rajaan. And that's the case that's put in the pleadings, that's the case the judge understood clearly, and all you need to know for that purpose is it's set out in paragraph 468 of the judgment, page 472 of bundle 2 of the core volume, by reference to the pleadings at paragraphs 87, 88, 92, 106, and 109.
So he's on their coattails.
He's very much on their coattails.
Right. So
More than that.
the only question arises then if they're taken to London, what happens to him?
Yes. If the A and B claims against Mirabeau are in London, we accept that the A and B claims against Mr. Argan would be. But that's just because it's the exact inverse of the position I'm advocating for. And it follows as night follows day that Mr. Argan must go with the Mirabeau claims. Now, and just so your Lordship and Ladyships have it, paragraph 466 of the judgment is where the judge rightly said that any liability of Mr. Argan is fundamentally bound up in his relationship with Messrs. Mirabeau and Fauché-Magnon. And that's correct, and it's not suggested it's not correct. And that's why I say it's at one remove. And so I make the point Mr. Davis made at the end of his submissions, although on a slightly different basis, that we do say it would be absurd if the scheme of the convention that is designed to avoid irreconcilable judgments dictated that the claims against the least connected target defendant, the least connected to the anchor, had to proceed in London when the claims with which the target defendant's really intimately connected have to proceed in, or will proceed in, Switzerland. And that's where, of course, the claims, there is the most serious and obvious risk of irreconcilability of the claims. And the fortunate coincidence in this case is that that's also the place of Monsieur Argan's domicile, where he was entitled to be sued unless one of the narrow exceptions to the Article 2 provision could be used by PIFs, which we say they can't. So that's why we say Mr. Adkin and all of the other respondents who made submissions on the principles under Article 6 were right, and why that's the only way one can construe Article 6 to avoid the kind of topsy-turvy result that would apply to Monsieur Argan and to Mr. Mirabeau in particular, if it were otherwise. In fact, it's the only construction, my lord and my ladies, that actually takes note of the word expedient in Article 6. Because the approach the claimants, the appellants, would have under Article 6 airbrushes out the word expedient as if it doesn't exist. And more than that, they would invite the court to be blind to the inexpediency, the obvious and blatant inexpediency of taking jurisdiction in London when it would result in a far more serious and fundamental risk of irreconcilability as between different sets of defendants. And that, in my submission, can't be right. Now, we set out all of this in our skeleton. It's at tab 17 for your reference. You may not have made it that far in the pre-reading. It's the very last one. And you'll find there, if it helps.
You should even think that.
you may have not read it with the concentration you had at the beginning of the process, may I suggest. But that's where we deal with the research in motion case and the Alpha Laval case, paragraph 17 to 19, which you'll see in writing there if it helps. Can I make one final point, since we're doing so well on time? And that's just that there was a suggestion yesterday from Mr. Beard, and it chimes slightly with my Lord's point a few moments ago, that there may be some difference in principle. Possibly my Lord was more talking about a difference in approach or in seriousness between the idea of suing a target defendant where there are claims against the same defendant abroad as compared to the position my client's in and Mr. Marshall's client, where there are no there are claims against related other defendants abroad, but no other claims that would have to be brought against my client abroad. Now, two things I would say about that. One is, if as we submitted collectively as respondents, Article 6 permits the court to look beyond merely the anchor defendant claim and the target defendant claim they wish to bring in London, there's no reason, of course, in principle at all, why the court should then be further restricted to only looking at the position where there are other claims abroad against the target defendant himself, as opposed to the position where there are claims abroad that are intimately connected to the target defendant's liability or claim against him, but happen to be against closely related but slightly different parties. It would be a distinction in principle that would have no grounding in principle. It would be arbitrary. I take your Lordship's point, my Lord, that there's a slightly more stark jar when you consider the position of a claimant who's to be sued in two different places, and there's a risk of two judgments against the same person being irreconcilable, although of course that's tempered somewhat by the fact that there may be issue estoppels arising before the second court gets to that stage. But the point of principle applies to both in my submission. The second point I'd take is, I was going to call it a technical point. It's not. It's quite an important point. This sort of distinction's never been floated before. Mr. Beard sidled up to it in his opening. And if you look at grounds 6 and 7 of the grounds of appeal, there is no suggestion that there is a difference in principle between the position my client's in and the position other respondents are in. And I venture to suggest that's because there would be no supportable principle that justified that distinction. But I do take the point, if it matters, because it's not in my submission open to PIFs, now to try to drive a different wedge between us, having failed to articulate that either in their grounds or either of their skeleton arguments. Those are the submissions I'd like to make, unless I can assist the court further.
No, thank you, Mr. Beard. Very well. Well, Mr. Beard, shall we start again at 5 to 2?
Yes, happily.